Primarily, I want to focus on the issue of the new public charge pronouncement or regulation that has been issued by the Trump administration. So that's going to be the primary focus of my discussion. And I'll be examining the issue within the context of of inadmissibility. Now, inadmissibility within the context of immigration law essentially is facts or anything that could potentially cause someone not to obtain a green card, right? So any disqualifying thing or any disqualifying fact that could cause someone not to get an immigrant visa to enter the United States, or if the individual is here in the United States and is seeking to adjust status, anything that could prevent or disqualify this individual from obtaining the green card. That is what essentially inadmissibility is. Now, there are instances where even though an individual is inadmissible, a person could obtain a waiver to circumvent the inadmissibility. So a waiver essentially is the way the government go about saying, okay, we realize and we recognize that you have factors or facts in your particular case that cause you to be inadmissible or ineligible for a green card. However, because of the compelling nature of your particular circumstances, because of those factors, we're going to circumvent the inadmissibility and still allow you to get the green card, right? So even though an individual may be deemed inadmissible, there are in most instances waivers that are accessible to circumvent that inadmissibility. Now, there are many factors, like I mentioned before, that can cause someone to become inadmissible or ineligible for a green card. One such example of something that can cause someone to be inadmissible or ineligible for a green card is you have a communicable disease of significance, of public health significance. So the CDC, which is the Center for Disease Control, they actually publish or they recognize certain diseases that could potentially affect the general population of US citizens. And if you are an applicant for a green card and you have these diseases, they could potentially disqualify you from getting the green card. So some of those diseases that are listed are gonorrhea, syphilis, something as simple as TB, tuberculosis, but if it's active in your system, that could also make you inadmissible. If you have something like leprosy and it's infectious, those medical diseases or conditions could disqualify you from getting a green card. Of course, like I mentioned before, there are waivers that could potentially allow you to circumvent the inadmissibility if you can demonstrate to the government, for example, yes, I do have this particular medical condition or this particular disease, but I'm the spouse of a US citizen or I'm the lawful permanent resident of a US citizen, then I could potentially still be granted the green card, having obtained the waiver and in spite of the inadmissibility. Now, also too, if you don't have documentation to establish that you obtain vaccination for vaccination preventable diseases, and here we're talking about like measles, rubella, polio, right? If you're seeking to get a green card if you're seeking to adjust status in the US to get your green card, and you have to do a medical. Everybody who's seeking to get a green card has to do a medical. And you go to the civil surgeon, the civil surgeon will test your blood, and they will examine you essentially to see whether you have these conditions or documentation to establish that you have been vaccinated against these vaccination preventable conditions. If you don't have the documentation, that fact could cause you to become inadmissible. Again, there are waivers to circumvent it. So for example, if you don't believe in getting a particular vaccination on the basis of religious or moral grounds, you can get a waiver, could potentially obtain a waiver for that. Now, an individual primarily, and these are the biggest factors in terms of inadmissibility. Persons who have been convicted of certain serious criminal offenses. So for example, if you have been convicted of a controlled substance offense, whether it's inside the United States or outside of the United States, anywhere in the world this happens, right? If this is established by law that you have this conviction, then this could disqualify you from getting a green card. And it generally does. Now, we have an interesting situation because here, for example, in New York, where we have the recreational use of marijuana is now being recognized as lawful or legal in some instances. But this is a situation where state law has not, well, federal law has not caught up with state law. So in states like Colorado as well, where the possession of marijuana for recreational use is allowable under that state law, the federal law still recognizes it as a criminal offense that could potentially rise to cause you to become inadmissible. So one thing I need to point out too about the controlled substance offense, there is an exception. If you have a singular conviction for possession of marijuana and the marijuana was in the amount of less than 30 grams, then this fact will not cause you to be inadmissible, right? So those are certain criminal offenses. That is one particular criminal offense that could cause you to be deemed inadmissible to the United States and ineligible for a green card. Also, if you have been convicted of an aggravated felony offense, an aggravated felony offense within the context of US immigration law is quite different sometimes from how it is understood within the context of state law. So an aggravated felony offense under federal immigration law would be, for example, a drug trafficking offense. And trafficking within this context is anything that requires compensation, any kind of remuneration, because you are, for example, you're selling weed on the street, even though it's a dime bag or a small quantity of it, this could potentially, this would, if you are convicted for it, be deemed an aggravated felony offense, disqualifying you from obtaining a green card here in the United States. And even if you have a conviction for something of that nature, like that, outside of the United States, that would also disqualify you from getting an immigrant visa to enter the United States. So these are some of the factors or the factual situations that could potentially cause an individual to be deemed inadmissible and thus ineligible for a green card, whether inside or outside of the US. Now, when it comes on to the issue of public charge and how it could potentially serve to cause an individual to become inadmissible, the Trump administration has not established, but they have kind of reinterpreted their position in terms of this factor. Now, what is a public charge as it is understood? With previously, before Trump introduced its new policy when it comes on to the issue. Previously, the concept of public charge was that, okay, if it's a situation that I need to rely on the government, I'm an applicant for a green card, but I need to rely on the government to provide me with sustenance in terms of cash benefit, or I am relying on the government to provide me with long-term institutionalized care, right? So I'm dependent on the government to do all of these things. Then these facts would indicate that I would be a public charge and therefore inadmissible, ineligible to obtain that green card, right? So those are typically the facts that would cause an individual to that would cause the government to deem an individual a public charge. However, usually, if it's a situation that if I'm an applicant for a green card and I can establish that, well, I'm not relying on the government to sustain me in terms of cash, money, or secondly, I'm not in need of any long-term institutionalized care from the government. And thirdly, I have someone that's sponsoring me and they can demonstrate that they have entered into a contract with the federal government and the state government to show that I won't become a burden or a public charge, then that which is generally deemed an affidavit of support would be determinative of the fact that I would not be deemed a public charge and therefore not ineligible for the green card. Now, the Trump administration has kind of turned this around because they have now restated or reinterpreted their position when it comes on to the issue. And they're saying come October 15th of this year, this is how they're going to redefine it. If you're here in the United States and if it's a situation that you are applying for a green card by way of adjustment of status, they are no longer going to look on the affidavit of support that your sponsor has submitted to be outcome determinative as to whether or not you would be a public charge. They are saying that they're going to take into account what is called a totality of circumstances, right? So they're now only going to look at the affidavit. They're not only now going to look at the affidavit of support, but they're going to look at a number of factors, of which the affidavit of support is only one singular factor. So they're saying, okay, the affidavit of support is a positive factor showing that you are not likely to become a public charge, and they will consider that. However, they will also now take into account many other factors, including your age. If you're under 18, but you're you're under 18, or you're over 61 years old, they will look on that fact as an adverse factor, as a negative factor, and weigh negatively against you in considering whether or not you're likely to become a public charge. And I think the reasoning behind highlighting those particular age groups is because they're saying that under 18 is less likely that you will be self-sufficient in terms of your ability to earn, and if you're over 61, they're saying that you're probably looking towards retirement as well, so you're more potentially likely to be on Medicaid or something like that. So you're more likely to become a public charge. Also, if you're applying for your green card, they will also now take into account whether or not you have any skills. You're coming to the United States, are you bringing any talents, any skills? What are your credentials? What is your educational level, right? Because if you're unskilled, you're uneducated, how employable will you be, right? So they will look on that factor as a negative factor, an adverse factor in this totality of circumstances calculation. Also, they will look at your household size and the income that is within your household to determine whether or not you would become a public charge. So if you're from a very wealthy household, right, they're going to look on that fact and it's going to weigh, positively in your favor, right? So, but the flip side of that is that if you're from a very poor background and you're coming from a very, impoverished circumstances, that now is going to weigh, heavily as an adverse factor. So it's really not a good thing, in my opinion. Also, they're saying that they will take into account many other factors as well in terms of your ability to demonstrate that you would or you would not become a public charge. And one of the strongest factors that they're saying that they will take into account in assessing whether or not you become a public charge is whether or not you have gotten public benefit in the past. So you're here in the United States and you have accessed Medicaid before you got a green card, or whether you access Section 8 housing before you got a green card. All of these factors, they are now going to take into account, and they will wait to see whether or not you are likely to become a public charge. So having gotten Medicaid in the past, or having accessed Section 8 housing vouchers, these things are now going to be adversely weighted against you in determining whether or not you become a public charge and thus inadmissible or ineligible for your green card. So the challenge is that a lot of persons out there now find themselves in the dilemma who actually do need the benefit and desperately need to have the benefit, but they are contemplating, okay, should I now access this benefit now that I desperately need, and then a year from now when I apply for my green card be deemed ineligible for this benefit because I previously accessed these public benefits in the past. That's now going to serve to disqualify me. So, of course, with the totality of circumstances factor, I don't think it's a good standard. I don't think it's a good standard because you can imagine going to an immigration interview, and depending on the temperament or the nature of a particular immigration officer, they may, in weighing these factors, decide that, you know, what exactly. So one interviewing officer may say, well, I think that you've met the requirement and you're not inadmissible because, well, the adverse factors don't weigh, as heavily against you as the positive ones, right? And another interviewing officer, maybe with the same set of circumstances, may say, you know what? I think that these adverse factors outweigh the good ones. Right, so again, you see that there's going to be a lot of arbitrariness in the system in terms of how the determination is made as to whether or not an individual would become a public charge. We can also see, too, how the policy is very elitist in its structure, right? Because it clearly benefits persons that are wealthier or from a wealthier background than persons from, a working class or a more impoverished background. So definitely there is the element of discrimination when it comes on to this particular issue that must be challenged. And the federal court in San Francisco, I believe, has now challenged the public charge factor as it's understood or it's being presented by the Trump administration in terms of its policy. So again, it's very difficult. A lot of people think too that because the Trump administration is saying that come October 15 of 2019, that is when they're going to implement it. But the United States State Department, which governs all the embassies and consulate abroad, they have actually been applying this since January of 2018. So more than 5,000 Mexicans in just the fiscal year, for the 2018 fiscal year, did not qualify for a green card simple on this new established basis for, grounds for determining whether or not an individual would become a public charge. So it's the consequences as they're being played out, it's very devastating, and it's very arbitrary too sometimes in terms of its impact on individuals that are seeking to get a green card. So again, we have, as a member of the American Immigration Lawyers Association, we constantly advocate that, these kinds of policies that are in place that are really discriminatory in terms of its application, we kind of push back against it, but we have to keep fighting, and we have to take political action as well to ensure that as members of the immigrant community, our interests are protected and fought for and defended.
Yeah, I just wanted to, first of all, thank you for this information, which I believe is, is necessary, especially in our community in which we live, in an immigrant community. And obviously the elitism, but also the level of subjectivity that now, because a person is of a certain race, they are automatically eliminated, if you will, and somehow geared towards Europeans, or an Asian, that have the wealth to enter this country. So first of all, I just want to thank you for that kind of information. And also the fact that you brought out in regards to Section 8. And so my question is, what is being done, knowing all of this right now in San Francisco or wherever, state governments, what is being done now to battle this or to bring about some sort of equity within the system?
Right. I think, let me point out first of all, though, you did mention that race was factored, would be a factor in terms of this determination. However, the government did not indicate that race would play a role. However, disproportionately, minorities typically tend to have less income or rely more on these public benefits oftentimes. So yes, it will disproportionately affect persons of a particular race or minorities, really. But I must point out, though, that the policy itself did not indicate that race was a factor that they would take into account in terms of making the assessment in the totality of circumstances test that they're using. To answer your question, yes, the court is where the battle is at in terms of whether or not the policy itself is discriminatory or even unconstitutional in terms of the way it's applied. It's going to go, of course, usually it goes to the federal court, and then it's appealed, and it could potentially reach all the way to the US Supreme Court. And they will be the final decider on the issue if it actually gets there. But in the meantime, too, it's a very political issue, and we need to actually be more vocal in our local communities, get in touch with our congressmen and women, and let them know how we feel about these particular things, right? Because they are there to advocate for our interests, right? So, we should never forget that as well. At the local level and the grassroots level, the church is always an important element of that factor. This is where people come to be informed, not just to be spiritually fed, but to gain knowledge, to become empowered.
ICE is going around picking up people. Is there anything that new that could enlighten us into this situation?
Immigration law is federal, yes, and it's standard, but there are also very local and very idiosyncratic ways that states and localities approach the enforcement of immigration law. So, New York likes to state that, well, this is a sanctuary city or a sanctuary state. As to how far that is true, we're not quite so sure, because I've actually had clients that were actually in criminal court proceedings that were actually picked up in the courtroom even before those criminal proceedings were completed. Right? So again, New York like to say, well, the only persons that Immigration and Customs Enforcement officials are picking up are persons that have been convicted for grave criminal offenses. But I know that as a practitioner of immigration law that is not the case. Persons who have not been convicted but were charged with certain criminal offenses have been picked up by Immigration and Customs Enforcement. New York is a little bit, I would say, it's better than quite a few of these states as well. A lot of these southern states, it's more aggressive. We heard about the situation in Mississippi where persons, they were just going to work at this meat processing plant, and more than 500, almost more than 600 persons were picked up by Immigration and Customs Enforcement, the majority of which were law-abiding persons living here in the United States with their families, and they were living here for a long period of time. So again, Even though the law itself should be uniform in terms of its application because it's federal, the enforcement of it, depending on the particular locality, varies.